Good morning, everyone. Welcome to Troutman's Post-Grant podcast series. My name is Maia Harris. We are excited to start with this first podcast in the series where we discuss strategy, trends, and other happenings at the PTAB. Look for a new one to publish just about every month, and please feel free to reach out with questions or suggestions along the way. I'm joined today by two of my partners. Andy Zappia in Rochester office. He is a partner in our Health Science IP practice group. Andy, thank you for being here.
Hey, thanks, Maya. Delighted to be here.
And Dustin Weeks, a partner in our IP practice group and resident in Atlanta. Dustin, welcome to you as well.
Thanks, Maya and Andy. It's a pleasure to join both of you. I'm looking forward to the discussion.
Yeah, I think it's going to be a good one. And I think because all good stories start at the beginning, our topic today is focused on IPR institution, more specifically, how to avoid it. So I thought I'd start with some stats here, because I like rooting around on uspto.gov every once in a while. And in the PTAB's fiscal year 2020, so far, that's October 1st, 2019 through September 30th, 56% of filed petitions were instituted last year. 64% of patents included in those petitions were part of the instituted IPRs. And if we drill down and look at outcome rates, which I think is what we want to focus on today, just focusing on the first two quarters of this fiscal year, 2021, here's what the PTAB's reporting. 18% of challenged claims were found unpatentable. So those were the ones that were part of IPR petitions. 37% of instituted claims, so those were part of instituted IPRs, were also found unpatentable. And if we look only at those claims that were part of final written decisions, so the ones that got all the way through, that rate's even higher. So 70% of claims included in a final written decision were found unpatentable. And if you compare that to success rates for patent owners, just for a moment here, only 6% of all patents included in IPR petitions result in a final written decision at all. So, given all of that number crunching, it's hard not to reach our conclusion here that maybe the best defense to an IPR is to avoid it altogether. What do you think, Andy?
Yeah, Maya, so absolutely. In the context of this discussion, we're sort of looking at this through the prism of a patent owner who's facing a petition. And for that patent owner, stopping an IPR early, that usually that involves preventing institution, is critical given the overall high rate of invalidation of challenge claims at the board. And if a patent owner is in the midst of trying to enforce a particular patent being challenged, stopping an IPR early is really important because of the stay mechanism available. Because if an IPR is instituted, the petitioner can go to the district court and ask for a stay. And while that's not automatic, and some district courts favor stays more than others, if a patent owner is trying to pursue an enforcement campaign with a patent, and an IPR petition is filed, that can be really problematic. So trying to defeat an IPR petition early is a really critical strategy for patent owners. And that's why there's so much focus on trying to figure out the best tools to use to knock out petitions early.
That's a really good point, Andy, just before you go on. So I had been thinking about this more in the context of you want to avoid IPR because you don't want to have to go through the whole process. You're saying that this is actually really important to the litigation strategy as a whole.
Oh, sure. And, IPRs happen outside the context of litigation. Sometimes patents are just challenged for competitive reasons. But a heck of a lot of IPRs are the result of an underlying district court case. And IPR process is fast compared to district court, but if a stay is issued, it can put your litigation on ice for, a year and a half, depending on when the stay request is put in. And given the invalidation rate at the board, if the IPR petition is instituted, it may be fatal to an enforcement effort on a particular patent. So that's why trying to knock these out early is so important for patent owners.
So you're a patent owner, as Andy just described, and you have an IPR petition that's filed, and you want to avoid it for all of these various reasons. What are your options? Dustin?
Yeah, so what Andy just said is you're looking at what are your tools that are available to you at this stage. And really your primary tool and really your only tool is your preliminary response as the patent owner. And, I think we're going to get into later kind of discussing like what you would want to include in that preliminary response. But just as a way of background, let's talk about what exactly is the preliminary response. You could think of the preliminary response as being comparable to a motion to dismiss early in a case in a district court litigation. So as soon as the petition is filed, which, maybe that's similar or analogous to a complaint, you're now going to look at that petition and you're going to look for defects in that petition. And you're going to file that similar to the way you would a motion to dismiss. So your preliminary response is due about 3 months after the filing date of the petition. And then the board will consider that preliminary response, and then 3 months after the preliminary response is when the board's going to issue a decision on whether to institute the IPR. So it's important to note that when IPRs first started, the preliminary response was very comparable to a motion to dismiss, and that the board kind of provided a presumption in favor of the petitioner on all factual disputes. Now, that's no longer the case, so it opens up the doors for patent owners to make a lot more arguments now than they could have previously made in actually challenging factual disputes. But yeah, that's really the background on what we're trying to do in a preliminary response, and maybe now we're going to kind of start getting into some of the specific arguments we can make in that.
Yeah, so actually, before we do that, though, I just wanted to follow up on that presumption question. So this isn't a 12b6 motion anymore where, we have to assume that everything that was pled is true. Have you seen kind of boards, kind of panels grappling with factual disputes and making determination if there is a factual dispute at that preliminary response kind of time frame? Are they actually making factual determinations now?
So you are seeing the board make some factual determinations now. Like it still personally to me feels like there still is slightly a presumption in favor of the petitioner. But we are seeing the board really look at the specific factual arguments that a patent owner is making, and the board is more willing to deny institution if it seems that really the patent owner does have the better factual argument in a particular case.
Oh, that's interesting. Okay, so I think you're absolutely right. Let's talk about kind of what we think the best approach is here. What kind of arguments are you guys making in these preliminary responses? Is this a battle of the experts out of the gate, or is it something different?
So this is Andy, and so there's a couple different mechanisms to try to defeat institution. First, whether a director institutes a petition is discretionary, right? So there's all these different kinds of discretionary arguments you can make about why the director should not exercise discretion to institute. And then there's also some provisions that, if violated, directly bar institution. And a lot of those are, they're mainly these time bar provisions, which I'll talk about those because we've made a lot of arguments on those in other cases. And then the kind of the third bucket is what Dustin was just talking about, getting into the meats of the merits on the arguments made in a petition. And petitions have to be based on anticipation or obviousness, based on patents or printed publications. And those are sort of invalidation arguments that a petitioner can make in a petition. So that third bucket is getting into the nitty-gritty on those. But let's talk about a couple provisions in the statute that just say that if you violate this, you can't get institution. And the key ones are 315A and 315B, and these are time bar provisions. So the first one is you can't get institution if the petitioner or a real party in interest challenged the validity of that patent before the petition was filed. This is basically one bite at the apple. If you tried it in district court, you can't later go to the board. A couple key things about that. Counterclaims don't count. So if you're a petitioner who was sued by the patent owner and counterclaimed for invalidity, that's okay. That doesn't bar you. And also, if you're a petitioner who's a defendant, the patent owner sued you on this patent, and you say that you're not infringing any valid claim, that valid claim language, the board has said that also is not a challenge to validity. So that doesn't trigger this particular bar.
But, just for clarity, hold on. So I just want to make sure that I understand this, because for clarity, it's not that there has been a challenge in the past. It's that petitioner specifically made the challenge.
Exactly. It's that petitioner or a real party in interest. And that's where this one comes up, because there's a lot of fights about who a real party in interest of the petitioner is. and you take a very careful look at who might have challenged a patent previously, and was there some kind of relationship there as such that a real party in interest of the petitioner challenged the patent. And that's the a ground where there's a lot of fighting about whether this 315A bar applies.
And so is that something that does that kind of spark its own like little factual dispute at this stage if you're starting to question who the real party in interest is and whether or not the 315 time bar actually applies to that petitioner, or how is that handled?
Yeah, there can be. So you can also try to get discovery in the preliminary response context, and we've done that because sometimes there's an issue about a relationship between the actual petitioner and a third party. And is that relationship such that they are a real party in interest, such that the conduct of that third party who challenged validity in a district court would bar the petitioner's petition? And you have to go to the board and ask for discovery and try to get some information. If your publicly available information is not enough to present the argument on that issue as a patent owner. But yes, in the context of preliminary responses, you can attempt to get some discovery. And we have been able to get, for some clients, some discovery on these time bar type issues.
And Dustin, I forget, you said that this all happens basically within about 6 months from the original filing of the petition, right? So we've got kind of the petition's filed, the preliminary response can be filed 3 months after, and then 3 months after that, the board decides whether or not it's going to institute. Did I get that right?
Yeah, that's right. So, if you're going to try to make one of these like real party and interest arguments, you're going to want to identify that pretty early on so that, as Andy mentioned, you can go through that process of trying to obtain discovery from the petitioner or maybe a third party on whether there may be these other real parties in interest that would bar institution in that sense, because you want that discovery in enough time that you can present that with your preliminary response, which, as we said, that's 3 months, or roughly 3 months, and usually a week or two after the filing date of the petition.
Happens quick, it sounds like.
It certainly does.
All right, so we've got real party and interest. We've got technical time bars. What else are you guys raising in these preliminary responses?
Well, there's one other technical time bar I probably want to talk about briefly, and it's 315B, and that's where the petitioner or a real party in interest with the petitioner was served with a complaint alleging infringement of the challenge patent more than a year before the petition was filed. So basically you have a 1-year time period to file a petition if you've been sued, right? And if you wait too long, that's another automatic bar. And this real party and interest thing comes up in this context too, because sometimes it's not the petitioner that was sued, but it was a real party and interest with the petitioner who was sued. And we had a case, this is public record, we had a case where we were patent owner and the petitioner wasn't sued more than a year before, but the U.S. government with which the petitioner was working was sued more than a year before. And we were able to get discovery on the relationship between the U.S. government and the petitioner, and ultimately the board determined that there was a real party and interest relationship there, and it barred institution based on the 1-year time bar. So that's just another example.
Interesting. So these time bars are real, and they're being used to bar institution. Interesting.
Absolutely.
All right. So we've got time bars. That sounds like something that's ripe to consider. What else are you raising in preliminary responses? Dustin?
So yeah, this is Dustin. Yeah. So Andy mentioned some of the statutory bars. Well, the statute also gives the board discretion to deny petitions on certain grounds, and we see a lot of that. And those are very effective arguments at the preliminary response stage. The statutory section that gives them that authority is Section 325D. And for the most part, I see, two primary arguments when you're arguing that the board should use its discretion to deny institution. The first one comes up when you have just repeated attacks by the same petitioner against a patent owner. And in this, the board is basically saying, look, if you want to file an IPR against a patent owner, we want to give you one shot to do it. But we're not here to let you have, 2, 3, 4, 5 bites at the apple where you try to attack the patent, we tell you it's wrong in some particular way. You use that to then go try to correct that deficiency and then refile against the same patent owner in almost a harassing manner to the patent owner. If you're going to try to attack the validity of this patent in an IPR, do it and get it right the first time. So if you're the patent owner, and you're involved in one of these proceedings where you're getting repeated attacks by the same petitioner, that's a strong argument that you can make. So the other situation where we see the board exercising discretion to deny petitions is when we're getting a lot of recycled arguments. And that's where you have a petitioner that's challenging the validity of a patent based on the same arguments that have already been considered by the office, either earlier in prosecution or in another petition for IPR by another petitioner. So here it's almost like on a cumulative prior art basis. The board is saying, look, if we've already looked at this argument before, even if you think that the patent office or the board got it wrong, don't come to us with the exact same argument. So and you'll see petitioners do this a lot where they, it's very common that either the art cited during prosecution or the art that was cited in a first petition, and that might be the strongest art. And they just really think that the patent office got it wrong on that one. So they try to kind of strengthen the argument even more. And they may try to say that, well, this is really a different argument because we're relying on a different section of that reference. Or, well, you didn't have the benefit of this expert testimony beforehand. So as a patent owner, you want to try to see through that and show to the board that, really the petitioner in this case is just trying to recycle the argument. They're, almost in a harassing manner again. As a patent owner, I've already gotten this argument made against me. I've overcome it. I shouldn't have to keep doing that over and over again.
So let me make sure I understand this, because it sounds like you use the term discretionary. Is there kind of, if you're thinking about challenging IPR or challenging a patent in IPR, I'm thinking about it the other way. You really believe that somebody else just botched it in kind of presenting the prior art that you think is the strongest. Are you worried about kind of getting kicked out because it's just a cumulative argument? Is there a number of petitions based on the same or cumulative prior art that you need to be worried about as here's the metric, we're just going over the metric now, they're just going to kick us out?
No, I don't think there's any bright line rule, right? But if you were the petitioner and you're trying to make essentially the same arguments that have already been made and just hoping that maybe you have a different audience that's more receptive to those arguments, you certainly need to be worried about it. And that's where you would try to introduce the new expert testimony that's tested, that's presenting evidence on a different aspect of the reference, that maybe your argument is, well, the argument I'm making is a little bit different now because this specific argument about the reference was not considered by the board or the examiner early in prosecution. But, you've got to be careful there. I always say you never want to make that your only argument in petition. Perhaps make it, but have some backup arguments as well based on different references.
Yeah, it's interesting because I think that, when we saw the kind of the IPR process kind of go through Congress, we were all kind of thinking of it as, well, maybe this is the way as patent owner attorneys and counsel, we actually get to a point where we're not dealing with these challenges over and over and over again. And it sounds like we're still kind of struggling with exactly that issue.
There have been so many IPR petitions filed. The board has been looking for ways to deny them, and this discretionary denial is an option the board uses quite a bit. And also, it's important to note that these institution decisions are generally speaking not appealable. So the board's decision not to institute is generally speaking not appealable to the federal circuit. So that's a final decision. And a couple other areas where there are discretionary denials. One is multiple petitions by the same petitioner against the same patent. Like I had a matter where the petitioner filed 6 petitions against one patent, and the board doesn't like that, and they require the petitioner to rank those petitions, and then you make an argument that, hey, you say to the board, you really shouldn't institute any of these, but if you institute any, you should only institute one. And I had one matter where a petitioner filed 16 petitions, and we were able to get 9 of them denied institution just based on this multiple petitions against a single patent argument.
You're talking about multiple petitions being filed all within roughly the same time period on the same
by the same petitioner within the same time period.
Yeah.
And the board really doesn't like that because they see it as really dumping a lot of work on them. So you have a grounds to just say don't let them take one shot, one petition. They shouldn't be able to pile on so many petitions against a single patent at the same time.
Right. And that makes sense, right? I mean, you want, I can see an instinct from the board's perspective to kind of force kind of petitioners to pick their best arguments and make those arguments, right? I mean, we're always told by everybody at the PTO and the PTAB, make sure that you choose your best arguments and focus on those. Don't throw us the entire world of prior art.
Yep, so. And that the board requires an actual ranking document. So if you file a bunch of petitions against one patent, same petitioner, you have to rank them. And then the board looks at the ranking and the arguments made, for example, in a preliminary response, and will decide if it's going to institute on any of them, but if it decides to institute, if it's going to institute on all or just the top ranked ones.
And that makes total sense to me. So we've been talking a lot about statutory bars and kind of these more technical aspects of kind of petition practice. Are you raising substantive arguments? Are you challenging the actual substance of the petition in these preliminary responses too?
Yeah, absolutely. I mean, you want to do that, but if you gotta go back to what we were talking about earlier. You don't want to get into a battle of a factual dispute if you can help it, right? You want to make that argument, but that one's more difficult to make at the preliminary response stage, right? Even though now we don't have the board giving a presumption in favor of the petitioner on all issues of fact, on close calls, you're not really seeing the board just deny institution. If it's a close call, the board's going to want to say, well, here, this is something we actually need to have the trial on. We need to flesh this out and make sure we get it right. But, on other kind of more substantive aspects, you still can attack on, if it's a 102 argument, failure to just establish that one particular limitation is met. We've all seen this in cases where, it's a limitation that maybe doesn't seem to be that important in the claim. But even if it's not that important of a limitation, if it's a 102, if it's anticipation, you still have to make out the case that every single feature of that claim is disclosed in the prior art. So to circle back up to what your question, yes, we're making the substantive arguments, but it's much more difficult, in my experience at least, to get a petition kicked out in the preliminary response stage just based on no motivation to combine or no reasonable expectation of success or non-analogous art, stuff like that.
Yeah. I mean, what about claim construction?
Under the rules, the petitioner has to address claim construction in the petition. And as a preliminary response strategy, you can get into one of the strategies would be to say that the claim construction is incorrect for these reasons, and based on a correct construction, the prior art doesn't teach certain of the limitations. So claim construction is something you definitely address, and as Dustin was saying, it's also important to focus on gaps in the petition, and this goes to this issue about trying to avoid a battle of experts or factual disputes. If the petition doesn't adequately address certain things, because there are requirements on what the petition has to address as far as the substantive grounds, whether it's anticipation or obviousness, that's a really good point of attack. Also, for non-patent references like publications, you have to authenticate that they were publicly available such that they were prior art. So sometimes people attack that authentication, like you haven't really shown this is prior art, so your argument fails. And these type of arguments are good for preliminary responses. And sometimes I try to avoid getting too deep into the weeds on specific sort of expert fights on 102 or 103, because when you put in a preliminary response, you haven't had a chance to depose the petitioner's expert yet. And petitioner's expert is going to read whatever you put in a preliminary response and prepare on that when you do get a chance to depose him or her when and if institution is granted, right? So you don't want to show your hand too much. So there's a careful game about making your best argument to try to defeat institution, but you don't want to educate your opponent such that they're ready for you when you depose the opposing expert. So that's sort of the weighing you have to do with a preliminary response argument.
Yeah, and that makes total sense to me. I mean, I'm just thinking about it in the context of, of course there's going to be some dispute over claim construction, I suspect, at some level in all of these. I'm not sure that means that you're going to be able to win on an institution basis, but maybe that's a substantive argument that you get to raise at trial. So it seems like some of these more substantive arguments would be harder to make than some of the technical arguments, the time bars, the statutory bars, you didn't authenticate your prior art argument. That feels like the right way to approach these things.
Just want to quickly mention one other discretionary denial ground that I don't know if we've touched on, and it relates to parallel district court proceedings. If there's a parallel district court proceeding where the same patent is being challenged and the same sort of invalidity arguments are going to be raised in district court, and that district court case might get to trial before an IPR would be resolved, that is a basis to argue for denial of institution. And the board has set out a 6-factor test for whether to deny institution based on a parallel district court proceeding. And this is an area that's been super active in the last year. And the board has actually changed the standard about a little more than a year ago in a decision. And this is one area where almost every IPR, when there's a parallel district court proceeding, you will see, unless that parallel proceeding is at an very early stage, an argument for denial of institution based on a parallel district court proceeding. It's almost standard to try to raise that to defeat institution.
So let me think about that just in terms of kind of the timeline. You're going to have to, for that basis of denial to work, you're going to need to be in a district court that's moving fairly quickly.
Typically, yes.
Yeah, you're going to...
Yeah. Go ahead, yeah.
And this is Dustin. I'll add that it's interesting because when the AIA was passed and these IPRs, they were supposed to be an alternative to district court litigation, right? But, of course, what we see is a lot of, especially your larger companies with deeper pockets, they're saying, well, I'm not going to use it as an alternative. I'm going to use it as a supplement. So I'm going to wait until exactly the end of that 1-year bar date after I'm served with a complaint. I'm going to litigate for a while, kind of see some of the positions of the patent owner, and then I'm going to file my IPR petition right at that 1-year date. And I think what the board was doing is they were seeing that and they were like, hold on now, that wasn't the purpose of these procedures. If you want to file your petition, bring it early on.
Yeah, that's so interesting because I think that I think that people were avoiding or trying to be a little bit more proactive early after the AIA was passed because they were worried if they waited too late they weren't going to get that stay by the district court. Sounds like they've, the flip side of that is they're going to try and extend and be in as many jurisdictions as possible. And once again, we all thought that this IPR proceeding was supposed to help us kind of consolidate our arguments in one jurisdiction or another. Sounds like we're still spreading out. We're diversifying our defenses as much as possible.
Absolutely.
So interesting. So, all right. So we've covered kind of our bases for preliminary response. We filed a preliminary response. What happens next? We just sit around and wait?
Petitioner can ask for a reply to a preliminary response. It's not automatic. You have to ask for leave from the board, but it's pretty standard that the board will give a petitioner a chance to put in a reply. Usually it's short. The board might give you 10 pages or 15 pages for a reply. A lot of times the board does not like new evidence submitted with a reply, so you got to ask for that. But after that reply goes in, then in 3 months from the preliminary response, you will get the institution decision. And if the institution is granted, then the proceeding is supposed to be concluded within 1 year of institution.
1 year of institution. Got it. So it sounds like you've got your preliminary response. There might be a little bit more paper filing, and then you just wait to see what the board does.
Exactly.
Wait impatiently.
Right. Yeah, that's right. Fingers crossed if you're you get a denial of institution if you're the patent owner.
Yeah, there's a lot of waiting in our profession, I think. So, all right. Well, gentlemen, it was a real pleasure talking to you today about this. Thanks to both of you. Thanks to our listeners for joining us. We invite you to join us for our next installment of this podcast. Next time, we're going to be talking about the exciting world of supplemental examination. Troutman Pepper's intellectual property team helps clients develop and implement global protection and commercialization strategies for intellectual property assets in virtually all industry areas. For more information about how we can help you, visit intellectual property section of Troutman.com. You can subscribe and listen to this or other Troutman Pepper podcasts wherever you listen to podcasts, including Apple, Google, and Spotify. Thank you so much, Dustin. Thank you so much, Andy. Thank you so much, listeners, and stay safe.
Thank you.
Thanks, Maya. Andy, it was a pleasure.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.